Well, we apologize for the imposition on council's time this morning. We did our best to schedule things, but anytime you've got 4 matters on the calendar, it's rare when we end up right on time. So we made an effort to make sure you weren't wasting a lot of your time here this morning. Missed our guest by about 35 minutes, and we're sorry for that. Mr. Johnson, you have requested and we issued an order permitting the photography, and I'm not sure if I need to. Sometimes when you send someone else to do this, I make this reminder. I assume it's not necessary when you're here, but part of the protocol is even if you get 10 minutes into this and think, phooey, I don't want to film this isn't interesting, you're kind of stuck because of the opportunity for others to have access to the film. You're in for a penny, in for a pound, and obliged by the terms of our order and the rule to film the entire argument. Does that point need to be made in the future, or can we count on you to make that
We are already aware of this, and we have never left early.
Good, excellent. Well, then I at least won't cover it again in the future, so long as we're
happy to address that.
Then you have all been here before. I won't add to the delay by going over things that you've heard before. We'll just hear from appellant whenever you're ready.
I was a little worried that her work side is going to get shown by that.
Well, it's too late to ask them to move to the
Nothing I
other
can
side.
do about that. It's a good thing I wore black. But Margaret Lindsay, Utah County Public Defenders Association, here with Daniel Shin, who is our youngest attorney. Makes me jealous at how young he is. Here on behalf of the mother in this case. Due to the sensitive nature of some of the facts involved in this juvenile case and the privacy of the children and the family involved, there may be times when I simply point the court to a page in our brief or generalize some facts in order to preserve and protect some of those privacy interests. About 15 years ago, when my mother was a juvenile judge, I was in the habit of frequently going over to her chamber for lunch. We'd meet up for lunch or at the end of the day. And about 15 years or so ago, I went over there one day, and she and Judge Noonan are hunched over just her computer. And I said, "What's going on?" And they looked at me and said, "You're better at research than we are. We need to know everything about the parental presumption and how it works in juvenile court. There's a case." And so, I sat down and helped with some research. And then, to be honest with you, until that time and until the time this case really began, I hardly thought about the parental presumption in all of those intervening years and through all of my juvenile court interaction. Yet really that is the issue, the primary issue that's before this court is, what is the parental presumption and whether the juvenile court erred in both its utilization and its application of that doctrine in the case at hand.
It can apply in juvenile cases, right?
Well, I guess that's a question. I mean, my assertion is that theoretically it can. I mean, when historically it was a judicial doctrine created in order to really protect a parent's rights and against a non-parent. And
Well, I mean, I'm looking at State Ex Rel KF, that Supreme Court case from 2009. They clearly discussed the parental presumption in the context of a juvenile court case. That case, however, was that was the individualized permanency case, and so the court was trying to weigh between parent and a sort of a long-term foster care placement. So we didn't have parent on parent there.
You have parent on state, and basically it was.
Yeah, it looks like the parental presumption can apply in juvenile court cases. I guess the next step in my mind is, can it ever apply in parent versus parent situations? What's your take on that?
Well, I think my take is twofold. I think in KF it really was a situation where there was an order of custody outside of the parent. There was reunification services ordered. There was a termination of reunification services and a change of goal to individualized permanency. And at that point, the parent tried to invoke the parental presumption saying, hey, I have superior claim to And the court, you can't change the goal of individual permanency. Some court may have, disagreed. It talked a little bit, traced the history of parental presumption, but it also makes a statement that the parental presumption does not apply, as the Court of Appeals has correctly held, to cases brought before the juvenile court on abuse, neglect, or dependency proceedings. So I would argue that, just that statement alone, and the decision of the court, indicates that juvenile court, it doesn't have much application in juvenile court. And here's why, in my opinion. I think the Juvenile Court Act basically trumps that judicially created doctrine. And that the Juvenile Court Act does everything that we need it to do, including considerations. If you look at the purposes, when it's talking about abuse and neglect cases, it talks about the court's ability to make placement, protection, custody orders in terms of abuse, neglect, and dependency cases. It also talks about that the purpose of the juvenile court is to act consistent with the ends of justice and in the best interest of the minor in all cases, and to preserve and strengthen family ties. So I think the Juvenile Court Act does everything and more that the parental presumption would ever be asked to do. And that being said, I apologize, I forgot the second part of your question.
Well, can it ever apply in parent versus parent?
It certainly has not, as of yet. I don't think it does. I think it was done something to protect.
None of the cases cited apply it in that context.
I think it was something.
Unless somebody's aware.
I think it was something that was created to protect family unity, the structure of the family, fundamental interests surrounding a family against attacks from the outside.
Okay.
And even in cases where parent, non-parent, where it applies, all it didn't put a party in superior position. It simply made it a broader best interest inquiry.
But why wouldn't it apply when you have a fit father versus a mother in your client's circumstances?
I don't think it needs to apply, number one, because under the Juvenile Court Act, when there's a removal from one parent, the court is first obligated to look at placement with the other parent.
Okay,
And then to make decisions as to
if that's true, then we're sort of getting to the guardian ad litem's sort of backup argument. In the guardian's brief, they sort of agreed that the parental presumption was misapplied here, but the argument being made is, well, it didn't really matter because the result was right anyway. And if what you just said is sort of where we go next, that even without a parental presumption, the court is sort of duty bound to look to the other parent in these cases. Why is the guardian wrong?
Well, I think for a few reasons. I think one, not necessarily wrong, but in this case, that would call for a different result from this court. One, that is the starting point of placement. Where should the child be placed if there's a removal? The second is, once there's an adjudication, what should the dispositional orders should be? What should the goals be? And in this case, the goal was set to return to the mother, was for reunification, which is a whole stage and a whole process and a lengthy thing. If that's not successful, or if the parties of the court decides otherwise, then something else could be done, such as the end result that happened here. Now, whether permanent custody and guardianship should be applied parent to parent is an argument for another day. But, in other words, I think what I'm saying is it triggered the goal of reunification, triggered other standards and other protections and other statutes. And that the judge, Bizzell, at this point, our argument is that really it was her understanding of the parental presumption of ours. We believe that she felt boxed her in, that it dictated.
I get that, but she's holding an expedited permanency hearing in this case, right? And at that hearing, among other things, she could have changed the permanency goal.
She could have, and I don't think the framework and the arguments that we're making, that I made in our briefs, are exactly the same. the standard would be, whether a continuation of reeducation service is as contrary to the permanency interest of the children. That should have been the focus. We believe the focus on her decision was simply the parental presumption, mothers lost it, fathers haven't, and a finding in the best interest. Now, her best interest findings are rather slim, let me put it that way, and not focused, I don't think, to the issue at hand. And we've argued in our brief, and I do want to be sensitive about the privacy issues, a whole list of reasons why we believe that termination of reunification services, or continuing of reunification services this time, was not in the best interest of the children, and was not, driven by the efforts of the mother or a lack of efforts.
That's a ruling that we would review quite deferentially, right?
There's two parts to that. In general, I agree that that's a ruling that would be, more deferential. I think it would have to be more of a clear weight of the evidence type of thing. Or if the court failed to consider facts, or failed to act, it failed to consider all of the facts, or considered all of the facts, and its decision was against a clear weight of evidence. However, proper interpretation and application of a statute is a question of law. And so, I guess one of the nice things about oral argument is it kind of gives you a chance to step back and view the situation. And if I had to say in one thing, I would say that the court's perception of the parental presumption caused her to interpret the statute differently than legally should have been. And then that application of that erroneous interpretation of the statute and what was required of her based on parental presumption, she simply didn't adequately apply or interpret the true standard. I see my time is up. And
You end it right on time, you'll have your rebuttal time, and we'll hear from the other side.
Martha Pierce, attorney guardian ad litem. I love that question. Why is a guardian ad litem run? Give me all the reasons why. But I want to tell you if I'm right. The parental presumption as it applies to a parent versus a non-parent is that the parent is presumed to be able to, their decisions are presumed to be in their child's best interest. In the juvenile court, we adjudicate, although we're adjudicating the child's status, we're adjudicating in a level of clear and convincing evidence because we want to empower the juvenile court to override a parent's decision-making ability, which is why the fathers were adjudicated, because the court's going to override their decision-making ability.
Because of the finding of dependency.
Exactly.
And so that's why you think the parental presumption doesn't apply in this case, because the petition filed by the state in this case asked for findings with regard to both parents, a neglect finding with regard to mom and a dependency finding with regard to dad. Do I understand your argument?
Yeah, that's de facto. We're at fault, and we're fit parents de facto, but de jure, that adjudication provided the court with authority to override their parental decision-making ability. So once they're both within the juvenile court's ambit, there's no reason to privilege one parent over another. It's going to be a fact-based determination.
I mean, that makes sense to me, frankly, and we're on the same page. So, but where do I go from there, right? So what you're asking us to do is sort of affirm on the basis of, well, even though the district court got this parental presumption wrong, the district court sort of landed in the right place anyway, right? Is that sort of?
Well, that phrase I would disagree with, but I don't think it's a difference without a distinction in this context, because if you read the whole thing, the juvenile court does begin discussions about the children's best interest. They talk about the difficulties that children were having with visits, with mother's instability, with here's a permanency, and the court essentially did change the children's permanency goal by vesting permanent custody with the fathers. That was a change in the permanency goal, and the statute gives the court quite a bit of discretion to change that goal, which the court did. So, and it just made sense. I mean, mother had not progressed past supervised visitation, and the whole time you have two perfectly fit fathers providing care. The juvenile court never saw that they needed to take any remedial steps. It was just, please cooperate with what we're doing.
Yeah,
So-
it does make sense on some level, and it would have, this case would have been a lot easier, I think, if the juvenile court had said, but even if the parental presumption doesn't apply, I make these best interest findings for these reasons, and so it's sort of an alternative basis. But she didn't really say that. She sort of wove together the analysis, and she kept coming back to the parental presumption. And I think Ms. Lindsay makes some good points that really did sort of drive the juvenile court's analysis.
If you go in the transcript, and I think it's around pages 29 and 30, or maybe it's 19 and 20, but at the end of her findings, she discusses the children's best interest at quite a length. And so she gives you a belt and suspenders, and I'm saying, let's go with the suspenders, even though the belt might have been iffy. And even the belt part, as I said, the fathers were de jure, their presumption was rebutted, but de facto, really, they had at all times proved themselves fit by providing such excellent care of the children throughout this case. So the court had a firm basis, and there's no reason for this court to reverse on a best interest basis, because that was never argued by counsel, and the counsel never asked for more detailed findings, and counsel never asked to come back for an evidentiary hearing. So the court made these best interest findings, and counsel never challenged those findings, and so this court has ample basis to affirm. Any questions on that? I would also refer this court to State versus Thornton, which says the court may have taken a circuitous way, but this court's job is to make an up and down ruling on the court's operative decision. So unless there are any questions, I will leave it at that. Thank you for your time.
May it please the court, counsel, John Peterson on behalf of the state of Utah. See, Mr. Pierce left me quite a bit of time. I don't know if I need all of it or not, but I'll attempt to answer your questions. I'd like to start out by discussing something that no one's actually discussed yet, which is the fact that mother didn't preserve her argument regarding the parental presumption. In her reply brief, she claims that she couldn't because it first came out in the order, and that's simply not correct. If you look at the record, page 475, that's base stamp number, the judge clearly said, as he's issuing the oral ruling, that this would be a different case if the parental presumption doesn't apply, but the parental presumption
If
does apply.
the point of preservation is to make sure that the trial judge has an opportunity to rule on it, if the trial judge actually does base a ruling on it, isn't it ipso facto preserved?
I think the purpose of preservation is to indicate to the court you believe the court is engaging in error. I think if counsel had merely said, Your Honor, I don't believe the parental presumption applies in a case as between two parents, to my mind, that would be preservation. But letting the court just go down the primitive path without even saying boo or suggesting, that the court's analysis is an error, then we have an appeal. I mean, that, to my mind, that's exactly what the preservation requirement is designed to prevent, is to basically, I wouldn't say that counsel tried to plant seeds of error, but I think that the preservation requirement does require you to at least, very least,
Did anyone argue the parental presumption, or did the juvenile court judge come up with it on her own?
It appears to me it's been basically sua sponte on behalf of the judge.
So what you're saying is we can't review something the trial judge does sua sponte unless one of the parties sort of calls the judge on it at the time?
I think that's a reasonable, I think if she basically said, wait a minute, Your Honor, I don't believe that applies. We maybe rediscuss this a little bit. That would set it up, at least it would be argued and give the court a time to address its own potential error rather than simply going out to appeal. And that's exactly what preservation is about, is not bringing things up on appeal that could have been addressed at the trial level and maybe resolved.
I wondered almost if those who were there and on the ground, even though they heard the trial judge speak in terms of parental presumption, understood in context that what she was really talking about was the family preference for appointment of a guardian. And, before we get to paternal grandparents and all the rest, first line of defense there is the father's, the natural father of the two children, or the one child, as the case may be. So she's intoning the phrase parental presumption, but perhaps it was clear to everyone what she was really thinking of was the parental preference as an aspect of family preference when it comes time to figuring out, well, what guardian then and what custodial arrangement shall we come up with? I mean, it seems like almost an inadvertent misnomer to me, quite honestly, that she spoke in terms of parental presumption when she meant paternal preference when the rights of the other parent have been substantially affected. Who then shall be the custodian? Well, it's not just up for grabs. There is, in fact, a family preference. That's clear from at least our case law, and I assume from the statute as well. And where do you start? How about the fathers? Now, if either of them don't pan out, do we have aunts? Do we have uncles? Do we have siblings of an adequate age? Do we have grandparents and so on? But the court, it seems to me, may actually have meant the family preference, not the parental presumption as we sometimes think of it in other contexts.
And if you look at the court's oral ruling from 475 on the record, she says, this is a shakeout at this point. The mother's parental presumption is rebutted. The court ordered the goal of adjudication. We have an unrebutted parental presumption in favor of the father who is now asking for custody. From a legal standpoint, the father's claims are superior to anybody else's in the courtroom. And perhaps that could read your way, but it also is what the parental presumption means. As a person who, as I noted in my brief, there's a constitutional component to the parental presumption. A fit parent who's not been adjudicated to be unfit under a long line of United States Supreme Court cases has a right to care and custody and control of their child absent a judicial determination that they are not a fit caretaker. And I think there's a question about whether dependency adjudication does rebut that parental presumption. I believe Ms. Pierce suggests that it does as well. And I agree. I would argue I don't necessarily know, but my analysis of the cases seems to be that it's the lack of custody, which is really the crucial component to losing the parental presumption. I mean, you have to have the adjudication as a constitutional component to it, but that and the actual loss of custody is what rebuts your entitlement to assert the parental presumption in the future, which didn't occur. I mean, it maybe occurred for a brief second in this case, but really the children went to the fathers almost immediately and remained there throughout the case, and we're doing well. I mean, and that gets to the point of Pierce, which I also agree with this, even assuming the parental presumption didn't apply, even assuming the court erroneously applied the presumption, the facts that lead you down to the path of you have a mother on this side who, despite 8 months of services, I mean, she may have done 15 of 8 things, but the things she did do, she didn't have a home. And by her own admission, the house was not a place for children. She worked graveyard shifts, and she hadn't even done her mental health assessment. The court findings, paragraph 5 and 6. The court noted, I mean, even if we started today, you're not going to get that. We can give you another 4 months of services, and you're still not going to get it because you didn't even bother to do the first thing, which we've been talking about in this case, and it's a big part of this case. It has been an issue in this case since the beginning. You haven't even gone down that road yet to beginning to start, whereas the kids have been doing with the parents, with the fathers, and doing fine. We basically have a father who has never had any kind of a fault-based adjudication that they have any parental deficiencies whatsoever. And a mother who has a neglected adjudication and has had 8 months of services and is still not really even started.
So in your view, father wins not necessarily because of any parental presumption,
He would win just
but because of the situation.
Yes. And I mean, I do believe there is, whether or not the parental, I mean, I think, yeah, like you said, there's no case really. I looked, I had my clerks looking, I've never found a case where it was applied between two parents. But I do think that some of the constitutional ramifications where you have not adjudicated a parent to have any fault, or to my mind, that still holds some sway. I think that's, even if the judge erred in calling that the parental presumption, I mean, I think she also said that that's what we've got in this case. We have.
But you are conceding that it was error.
I don't know that I would. I mean, I stand by the analysis I made in my brief because I think it could. I don't see any logical reason why you have one parent. If you had a different situation, if you didn't even have an adjudication against a father and you had a mother who was adjudicated, I think it's pretty clear that I think that an adjudicated parent has a constitutional entitlement to custody and control of their child. maybe the dependency adjudication is enough to invoke. I mean, there's case law to suggest that is enough. I mean, so I don't know if I would concede error, but I would concede that if there was error, it's harmless error, as Ms. Pierce argued in her brief. If there are no further questions, I think those are the points that I wish to cover, and I think the court understands the issue before it. Thank you very much.
Thank you. We appreciate the argument. Ms. Lindsay, you have the last word.
Wow, that's unusual. Few points is, first of all, this court issued in this case a very specific briefing order. And it's that briefing order and those questions which appellant and the mother sought answer. Second is to the preservation. I would direct the court's attention to the case of DB versus State, very similar to a delinquency case, but it was still a very similar situation. And we would argue that that analysis applies here, that the issue is preserved. As that court indicated, a general exception to the preservation rule. And I think in part driven by what Judge Harris had to say, is that the issue was clearly before the trial court. The trial court ruled on it.
And we asked for a briefing on it.
And you did ask for a briefing on it, so we briefed it. The children were already in the custody of their father. I think one thing for this court to consider is that a permanent custody and guardianship award in the juvenile court has specific meaning that doesn't attach in district court. And so it's not an insignificant thing. What this order did was essentially close the case, terminate jurisdiction, preclude, at least from the juvenile court perspective, any chance for restoration of custody by the mother, and left a very limited visitation order of supervised third-party visits going forward in this matter. That's not insignificant.
What if she gets her life in order a little bit better a year from now? Can't you're saying she's without a remedy?
That's an open question, because the juvenile court under a juvenile court order, when permanent custody and guardianship is invested in an individual or person, a parent is unable to re-petition for restoration of custody. A third party could. The father could. Suppose the guardian ad litem could, but not that parent. I don't have the answer as to what happens and how the interplay of that order affects the ongoing jurisdiction of the district court in terms of a divorce case. I don't know the answer to that. But it's important. Awards of permanent custody and guardianship, especially in divorce situation and parent situation, are not insignificant in the juvenile court. And it has very specific meaning, permanent custody and guardianship, within the juvenile court. And so I think the real question here is, I think one of my points is, in my opinion, the Juvenile Court Act covers everything that this court and that parties needed to cover in terms of orders that arise out of abuse, neglect, and dependency proceedings. I don't think there's any need or any reason to muddy the waters with the parental presumption doctrine. I think it was confusing to some judges I know 15 years ago. I think it's still confusing to juvenile court judges. I think it's the Juvenile Court Act covers it. To me, Judge Harris, the real question is, it's not whether the mother wins or the father wins in this situation. Juvenile court cases, in my opinion, the juvenile system is at its best when cases come to their natural conclusion. And most times they do, but sometimes they don't. And this is a case where we believe it didn't. And the real question is not whether mother wins or whether the father wins. The question is whether through the juvenile court's order and her interpretation of the statute, the law, and her application, did the children win? Did the juvenile court's ruling adequately consider whether continuation of services were in the permanency interest of the children, or in their best interest, to continue. Obviously, there were still ongoing needs, I believe, in this family, and I think those needs for the children, the needs for better communication, problem solving, were all there. And I would urge the court to examine that question. But that is the real question, is where did the children win? Were their best interests, their permanency interests best addressed and adequately addressed by the juvenile court? Thank you.
Thank you very much. We appreciate the arguments all around. They've been very helpful indeed to our understanding of the case, and we appreciate your sharing your time and energy with us. We'll take the matter under advisement and let you have a written decision as soon as we're able to get that taken care of. And with that, we'll be in recess until tomorrow.
All right.